Yes, I think we are half an hour. Are we ahead? Perhaps I've got a different. Half an hour, I think. Guernsey 3 was due to start at 2:30. So now we've got this document. Present trustees.
I just wanted to say, Lordships have the document. I was not going to say anything about it because I don't want to take any of the time from G3. I'm happy to answer any questions either now or if your Lordships have any questions, it could be done. If the registrar sent a letter, we've tried.
Well, there'll be some other reading lists, so
I won't say anything unless your Lordships ask me to.
Thank you much indeed.
Could I ask for an electronic copy? In due course, no hurry.
Of course, why not?
Right.
Yes, I think
On move to the completely different subject.
completely different subject. I think on my calculations we're 15 minutes ahead of schedule. We're certainly a few minutes ahead.
Well, it depends.
You're looking at the old edition.
I'm looking at the old edition. Thank you. Yes,
It's,
quite right.
you're 15 minutes ahead.
15 minutes, right? Good.
We have that luxury anyway. As your lordships are aware, you directed Summerfield to be dealt with by written submissions.
Yes.
My submissions are limited to the abusive process, where we succeeded in fighting off the strikeout before the
Lost in the Court of Appeal.
Lost in the Court of Appeal. Very brief chronology of the main dates, if I may. 3rd of March 2010, the G1, as I call it, if I may, brought by the former trustees against the BVI companies for directions seeking declarations in relation to the intercompany loans and whether the former trustees were liable. July 2010, Rawlinson and Hunter take over from the former trustees as trustees of TBT. 6th of July 2011, Rawlinson and Hunter are joined as a defendant to G1 at their own request in order to contend that if the loans are binding on the former trustees, then either gross negligence or unreasonably incurred liabilities by the former trustees. November 2011, Rawlinson and Hunter bring and obtain from Lieutenant Bailiff Chadwick delivery up of files of the former trustees who had been claiming a lien, as a result of which 50 to 70,000 documents were delivered to Rawlinson and Hunter in about January 2012. June 2012 was the 12-day trial Guernsey won before Lieutenant Bailiff Chadwick, and on the 25th of June 2013, whilst the parties were waiting for judgment from the Lieutenant Bailiff, Rawlinson and Hunter brought the G3 claim, as it's referred to. Now, if I can show you the judgment of the Deputy Bailiff, and just so that your Lordships can see the architecture of that. It is in, I think we have in respect of G3 electronic page numbers that I think your Lordships have, and my references are EP.
I had difficulty making them square with all the ones in the margin of your case, but yes. I may be wrong about that. I have hard copy bundles with pagination, and they all say on it electronic page number. Yes. So I'm hoping that that will coincide to the EPs, electronic pages that your Lordships have.
Let's see.
Let's as your Lordship says. If you go to, please, to electronic page 76. So
is this the e-bundle received 23rd of November for G3?
I hope so.
Let's hope that.
So if my friend wants the hard copy...
Could you give it the hard copy?
Yes, of course.
Too?
So that is agreed bundle 1, page 68. EP 76. Can I inquire whether your Lordships have paragraph 85 at EP?
That works.
That is going well so far. Paragraphs 85 to 91, the Deputy Bailiff went through the question of overlap. I'm going to come back to overlap. At paragraph 92 onwards, page 78, he then reviewed the arguments on abuse, and they are summarised, what he said in our case on G3 at paragraph 11. Having looked at the overlap, essentially, he considered what he regarded as the evidence before him about the delivery up application and the circumstances of the documents becoming available, found that Rawlinson and Hunter had not kept G3 up their sleeve, that's paragraph 97, and criticised the Rawlinson and Hunter for not the breach of what's referred to as the oldie stores guidelines. This is paragraph 98, which your lordship is familiar with, where the requirement that if new claims could have been brought in an existing action, they should be drawn to the court's attention with a view to the court considering what to do. Rejected in paragraph 98 the reason given, which was 96, I think, that funding was needed. And the key paragraph is 104 on electronic page 81, where he reviewed the position, took the view that the BVI companies would not have wished, because of course they aren't party to G3, but we're parties to G1, took the view about 5 lines in, the BVI companies would not have wished to have the claims heard at the same time. A couple of lines later said that he would expect the trial of G1 to have doubled in length, and about 3 lines after that said it would, in his view, have been transformed into quite a different trial if the allegations now raised had also been concluded.
Can you just identify for me precisely when, under the Aldi guideline, should the mention have been made to the court of the possibility of G3?
I don't think the Aldi guidelines identify.
No, I mean, in this case.
Well,
just chronologically.
That begs a question in a sense. If one takes the view that once the documents had been reviewed, they were received in January 2012, it would be they're 50 to 70,000 documents, then, and as I'll show you in a moment, much of the reason for seeking those documents was to ascertain whether there were claims to be made. Then I suppose the logic would be by the time those had been read, if they had been read, which they weren't on receipt, it would have been probably March or April 2012. However, I say that slightly cautiously because the Court of Appeal essentially said, we don't know from evidence exactly what you thought when you read them or what you would have thought. So I think one must be slightly careful about that. So 104 in a sense, if we just...
Sorry, Mr. Hollander, I'm still struggling to try and find the relevant electronic bundle.
Oh, I'm so sorry.
Is it e-bundle received 23rd of November?
Yes.
Yes. And the...
That is a 35-page bundle? No.
No.
Several
Right,
thousand.
well, that's what I'm getting.
I've got 7 hard copy files, so it's about
3,399 pages.
Yes.
Right, well, I'm getting something completely different when I click on that one. Sorry, let me just see whether I can... Now, what I get when I click on that is Statement of Facts and Issues on Guernsey 1.
If your worship really hasn't
I mean, I've got the hard bundles. I'll have to...
I wonder what the easiest way of making it available to your
Actually,
lordship.
find the hard bundles and use them, assuming I can identify them.
Well, you can get the judgment, I think, from a thing called Agreed Bundle 14th November 2017 PDF.
Well,
You've
maybe
got
that's...
that. It's 1, 2, 3, about 10 down on the home page.
Just tried to email it to you, but it's too big for the server.
That may have most of the documents.
Oh, I could put it on a memory stick.
I think you'd better
Well,
continue
I'm
while
not
struggle.
happy if your lordship hasn't got them. I mean, I'm sure we
Yeah,
can make
well,
available hard copies if necessary.
Right, I mean, somewhere among the 300 bundles around here, there's presumably the 7 that I actually need.
I mean, would it help if someone came to assist and to find them for you?
I think we won't have... I think the usher can do that. We won't have counsel scrabbling around underneath the bench.
Down here, is it somewhere? What's it look like on the back? 1 of 7.
1 of 7.
Oh, I don't have a spare.
I've got the spelling here. going to need our quarter of an hour.
Thank you. Okay, I seem to have discovered a secret stash of the relevant documents.
I was going to, so it was, the paragraphs I was referring to in respect to that from the Deputy Bailiff, I think 104 was the key paragraph, but I'm going to turn now, if I may, to the Court of Appeal and see their approach, which is electronic page 25, tab 1, at hard copy bundle 1, page 17. Bundle 1, page 17, electronic page 25. At 86 to 88 paragraphs, they deal with overlap, and again, I'll come back to that. Their analysis of beyond that starts at 89, where the Court of Appeal in 89, first of all, electronic page 26, 1/18, say that in their judgment, the bailiff erred in taking into account a matter which in the circumstances before him was irrelevant, what might or might not have happened at a case management conference. And then they go on to say, general principles, person not to be vexed twice unless good reason. In circumstances before the deputy bailiff, the present defendants are about to be vexed twice. And then in the last sentence, what's lacking before this court is, as it was before the deputy bailiff, is any sufficient evidence or reasoned basis to explain when the claims in this cause were first identified and why the new allegations weren't brought in Guernsey 1. And then in 92, after 3 lines in, however, there's no evidence the proposed new allegations depend on information only discovered from an examination by the plaintiff of the documents recovered in late 11 or early 12, nor any suggestion the proposed new allegations depend upon witness evidence from individuals not known or available to the present plaintiff prior to having access to the documents. On the contrary, amongst the relevant witnesses would be those giving evidence on G1. In 93, which is a key paragraph, in almost every civil litigation comes a point when the evidential burden moves. So this is their view, from one party to another, and may do on more than one occasion. Here, the deputy bailiff, having identified the present plaintiff could have raised the relevant part of the cause as part of Guernsey 1, should have recognised it was incumbent on the plaintiff to explain credibly why it wasn't done. Failing such a credible explanation seems to us to follow on the balance of probabilities. The party complaining is entitled to a determination the failure to raise in the earlier litigation that which could have been so raised is an abuse through double vexation. Absent that credible explanation, consideration of what might or might not have occurred at a case management conference was an irrelevant consideration, as the complaining party was already entitled to the order striking out the offending pleading, maybe exceptional circumstances where the outcome of any hypothetical case management decision would have been so inevitable the court could take it into account in a strikeout, but manifestly that wasn't the case here. And then just finally on this, at 93, in the second half of that, making the same point, just starting about 7 lines in, the learned deputy bailiff expressed the view the failure by the present plaintiff to raise its new allegations, the court sees the first matter, would have posed considerable problems for it if the allegation of abuse had been determined in England.
Sorry, where are you reading now?
I'm so sorry.
No.
95, about
95.
6 lines in,
Yes,
if you
yes,
have the learned deputy bailiff,
Yes, express the view, yeah.
expressed the view, the failure to raise its new allegations would have posed considerable problems for it if the allegations had been determined in England. He appears to indicate here the position wasn't determinative, failed to be more forthcoming with the defendants, and the lieutenant bailiff tipped the balance towards abuse, but wasn't a complete answer. We have difficulty with that approach. Once abuse has been identified, the court should strike out the abusive pleading on the absence of wholly exceptional circumstances. So one can see from that apart from the discussion of overlap, which I'll come back to, there is no consideration of the detail of the balance in the Court of Appeal judgment at all. The view they take is that having been taken that these matters could have been raised in Guernsey 1, the defendants were entitled to have it struck out for abuse unless a proper explanation was given and the burden had shifted. Now, in my submission, that is plainly a wrong approach, and it's wrong on authority. What I want to do, if I may briefly, is just take you to some recent authority. There's a couple of recent English Court of Appeal decisions. The starting point on authority is Johnson and Gore Wood, that your lordships will be familiar with, and we've set out a lengthy passage in our case which deals with this at paragraphs 15 and 16. The second authority, the authority that's referred to in all these cases, is Lord Justice Thomas in Aldie Stores, which I'm not going to take your lordships to because it's referred to in other authorities. Essentially, if the matter could have been brought in the first action, as both courts have held, then there's an obligation to raise it. And Lord Justice Thomas in Aldie Stores makes that clear.
In what sense is the word could? I mean, as a matter of law, this is the sort of point that could have been joined legitimately, or does it mean could in the sense that if you had raised it in March 2012, the parties to a trial which was going to be in 3 months later would have had no viable objection to your joining?
It certainly doesn't mean the latter. I don't think anyone's actually identified exactly what it does mean.
I think
it
means you can join lots of things in one action.
Yes,
but
it
doesn't
means,
mean say you're...
If the relationship between the two is sufficiently close, I think that's really what all could means in this context.
Yes.
I don't think that courts have actually... Let me show you...
there are lots of actions which could be brought together, which it would be entirely legitimate not to bring together.
Your Lordship is absolutely right, and I don't think the authorities really focus very much on exactly what is meant by could. I want to show you first of all...
Well, it means could in the Henderson and Henderson sense, doesn't it? Because the old law before Johnson and Gore Wood was that if you could, you were out. And that was all based on Henderson and Henderson. Maybe slightly simplifying it. It was probably
Yes,
more delicate.
that may be right. I'm not sure. I was going to show you...
abusive not to do it. I don't
Well,
think
it was,
Well,
if you could,
what
it
the
was,
Court of Appeal have said, as your lordships have seen, is that once you've got to could, that's the end of the matter, unless the plaintiff discharges the burden.
Yeah.
And that there are major problems in my submission with that. Can I show you first of all very briefly? I want to show you in particular the recent English Court of Appeal decision in Otcrity. But can I first of all just briefly show you Henley and Bloom? Now, again, I don't know whether you have electronic pages for the authorities. I've got three bundles of authorities without any electronic pages. But it's tab 16 of volume 1 in the authorities bundle, Henley and Bloom.
3585.
we have... Yeah.
It's
These
3585.
additional to the 7 volumes to which you referred a moment ago.
Yes. 3585 is the electronic page number. And this is, you can see how long ago this case was because it's Lord Newburgh was still Master of the Rolls. But an appeal from the Brighton County Court. And I only wanted to show you this case for the statements of principle. And if your lordships were kind, it's paragraph 18 of Lord Newburgh.
Is it volume
So in the hard copy, it's volume 1, tab 16.
116? Thank you.
Where are the rest of them? Okay, thank you.
This is the point. This is Johnson and Gore Wood.
This is Johnson and Gore Wood. Lord Millett
Can you repeat the volume and flag number again, please?
I'm so sorry.
Can you repeat the volume and flag number again?
Oh, it's volume 1, tab 16,
Thank you.
paragraph 18. Lord Newburgh refers to Lord Millett in Johnson and Gore Wood. It doesn't follow from the fact that a potential claimant could have brought his action as part or at the same time as the earlier action that he should have done so, or his failure to do so renders a later action oppressive or an abuse. He then makes the point that there was no presumption against the bringing of a successive actions, and the burden should always rest on the defendant to establish its oppressive or an abusive process for him to be subjected to the second action. So that's contrary to what the Court of Appeal did. If I then show you 21, please. The question to be considered, 21, on the issue of whether a fair trial is possible has been authoritatively stated by Lord Justice Chadwick, none other, in these terms in Taylor and Anderson, at paragraph 11. He said that proceedings ought not to be struck out unless an unequivocal affirmative answer can be given to the question, is there a substantial risk that a fair trial is impossible? And finally, in 25 and 26, and 25, again, there's a reference to Johnson and Gore Wood. And if you look at the last 5 lines, however desirable it may be for a party to bring all his claims forward in one go, the abuse principle, as the judgments in Stewart underline, does not bar a claim simply because someone fails to raise a claim when he could have done so. The facts must be such that the second action amounts to an abusive process before it can be struck out. And the importance of the 26, the importance of the general principle that every person with an arguable claim should be able to pursue it in court is enshrined in Article 6, and so refers to the fact that if the court isn't satisfied, a claimant's attempt to raise his claim is actually abusive in the light of his previous failure to raise it, the claim cannot be barred from proceeding, however desirable it might have been to have raised it earlier. And the case I then wanted to take you to is the very recent, there's 2 recent English Court of Appeal decisions. One is slightly on its own, to similar effect, but the one I wanted to show you is Otcrity, which is Authorities Bundle 2, tab 25. So, in fact, both these Court of Appeal decisions post-date the Guernsey Court of Appeal. This one is April 2017. And the page, so 3803 electronic page. One of the things that is interesting about this judgment is that you see at the top, it's a judgment by Lady Justice Arden, and we see Sir Geoffrey Voss at the top, but by the end of the judgment, he's mutated into Lord Justice Henderson, for reasons that are not altogether obvious. But leaving aside that, sorry. You can see that from paragraph 66. Sorry, there are more important reasons for reading this case. So you'll see in paragraph 2, what happened was that Otcrity had failed to join Threadneedle in previous proceedings. So there was a 46-day trial, paragraph 3, before Mr. Justice Eder, against a number of defendants, against a number of individuals, including an employee of Threadneedle, but not Threadneedle itself. And they now sought to make Threadneedle liable on the basis of vicarious liability. So you thought on the face of that probably wasn't a bad allegation of abuse, but so that was the issue. Paragraph 9. So we see Mr. Justice Knowles at first instance had not struck it out. In paragraph 9 in Lady Justice Arden, towards the end, the last 3 lines, having said that Mr. Guernsey, who was a defendant to Action 1, was employed by Threadneedle. So the attempt was now in the second action to make Threadneedle liable vicariously for his actions. The judge found that Otcrity would have appreciated then it might have a claim against Guernsey's employer at that date, but at no time did Otcrity take any steps to join them in Action 1 or seek management directions from the judge to whom the action was assigned. And then at 11, Mr. Justice Knowles directed himself under Johnson and Gore Wood. Claim should be struck out as an abusive process only if on a broad merits-based judgment taking account of both private and public interests involved in all the circumstances, it was clear that Otcrity was misusing or abusing the process of the court by raising an issue that could have been raised before. And then he refers to Henley and Bloom, which we've just looked at, that if it's struck out merely because it could have been brought, that would violate Article 6. 14, the judge took the view that where a party had not complied with the Oldie guidelines and the court was asked whether this was an abuse, the court ought to go on to consider as best it could what would have happened if management directions had been sought. He considered there should be a high threshold for concluding that non-compliance with the Oldie guidelines was an abusive process. And of course, that's very different from what the Guernsey Court of Appeal. 17, judge found that even if Otcrity had complied with the Oldie guidelines, Commercial Court would have declined to make an order to join Threadneedle because that would delay the trial. There were legitimate reasons not to delay the trial, reasons why it might be delayed. For example, Threadneedle would bring in a substantial legal team and might wish to bring contribution proceedings against defendants and their employers. And then 18, the judge considered no hard and fast rule as to when an employer should be joined if an action brought against an employee. If Threadneedle had been given the option, it would have refused it. It had been aware of the litigation, but had not sought to be made a party to it. And then if we can turn, please, to 44 in Lady Justice Arden's discussion. The reason I want to read you 44 is this is the other Court of Appeal case. I'm not going to take you to it. I'll tell you about it in a moment. It's Clutterbuck and Cleghorn, heard by Lord Justice Kitchen-Floyd, also 2017. Claimants made allegations in the first action of wrongdoing under 3 joint venture agreements. Claims to enforce 2 of those agreements against 1 co-venturer failed. In the new action, claimants sought to hold the defendant, who was not sued in the first action, liable. Judge struck out the claims in the second action for failure to comply with the Oldie guidelines. Court held Oldie guidelines were mandatory. Failure to follow them was important but not dispositive factor for the judge dealing with the strikeout application to take into account. The court upheld the decision of the judge in respect of 2 of the joint venture agreements, but the third was not an issue in the first action, or accordingly contrary to the judge, no abuse in respect of that. And then 47, when Lord Justice Thomas, and that's in Oldie, held at the end of the passage set out above that there could be no excuse for a failure to follow the Oldie guidelines, he meant there was no exception. It would not be open afterwards to a party to claim it was not bound to seek management directions about a proposal not to join a party against which it might subsequently allege liability arising out of substantially the same facts. This is how it's been interpreted in other decisions. 49, and the submission was made, Mr. Malek's submission, once the judge found that Otcrity had acted in breach of the Oldie guidelines in Action 1, Action 2 was an abusive process and should be struck out, which is essentially what the Guernsey Court of Appeal had held, unless there was the burden had gone the other way. In my judgment, that approach is clearly not consistent with Johnson and Gore Wood and its adherence to a broad merits-based assessment of whether a second action was an abuse of the process of the court. In my judgment, it's clear this court in Oldie did not intend to depart from Johnson and Gortwood. There is no hard-edged rule of law that a claim which a party could have raised in one set of proceedings will be struck out if that party seeks to bring it in another set of proceedings. The Oldie guidelines are a facet of the principle of a broad merits-based judgment as to whether this is the just outcome established in Johnson and Gore Wood. Accordingly, the judge did not err in his approach. And then the next bit is important because it's the same as was found in this case. There was no excuse for Otcrity not seeking management directions about the potential joinder of Threadneedle as soon as it had decided to apply to join Gersamia. And it could have sought management directions on a without notice basis in the first instance of the same application. When it made Gersamia a defendant, in March 2012, Otcrity could not but have known that it had a claim against Threadneedle too if the claim against Gersamia succeeded. So, Lady Justice Arden making clear that there is no excuse given for the failure to seek directions in accordance with the Oldie guidelines. At 50, she then, 51 over the page. In addition, no, I think 52. In making a broad merits-based judgment, the judge was clearly entitled to assess the seriousness of the breach and so to seek to determine what would have happened if the necessary application had been made. So I reject Mr. Malek's submission, which was an important part of his submissions, that he should not have attempted to determine the hypothetical scenario. So again, the Court of Appeal in Guernsey here, contrary to what Lady Justice Arden is holding, said it's irrelevant what would have happened at a case management conference, which is what the judge had sought to do at first instance, the Deputy Mayor. The case was different from those such as Clutterbuck, where the court couldn't determine what the judge in the first action would have done. And then finally 53, For the same reason, the judge was bound to consider the measure of the prejudice suffered by Threadneedle. That was one of the relevant circumstances. Mr. Malik is unable to point to any very specific examples of prejudice. There's no suggestion of prejudice here. A party needs to show more than the generalised prejudice to obtain a strikeout. In any event, Threadneedle knew all about Action 1 and could have intervened if it wanted to do so. It's difficult for a party which has never been sued by the claimant to complain that the commencement of a new action against it's oppressive or unjust, though I wouldn't go so far as to suggest it could never happen. It's also a relevant factor against Threadneedle in any broad merits-based assessment that if it successfully strikes out Action 2, it not only obtains the windfall of never having to defend Otcraty's allegations, but also altogether prevents Otcraty from having any access to the court for the purpose of determining its claim against Threadneedle. In finding there is a high hurdle, I bear in mind that if Threadneedle's defence is a good one, it will be able in due course to resist the claim. In those circumstances, a strikeout of the claim would not be appropriate or proportionate. Now, in my submission, that is the correct way of dealing with an allegation of abuse in accordance with Johnson and Gorewood, and that is an approach fundamentally different to that which the Court of Appeal adopted. Can I mention briefly, without going to it, the Clutterbuck case? I think we saw a moment ago, because this is another 2017 English Court of Appeal decision, and I think we saw the paragraph in Lady Justice Arden. The plaintiffs had a series of property joint ventures. There was a 3-week trial before Mrs. Justice Asplin involving them and another party, Alamoudi, with an extensive overlap. The Court of Appeal, the judge struck out all 3 claims. The Court of Appeal struck out 2 of the 3 claims. The one they didn't strike out is called the Cliveden claim. And if I can refer, without taking your lordships to it, to 2 points. First of all, the Court of Appeal noted that in that case, the allegations which led to the second claim had been raised before the Alamoudi trial, and the defendant had actually tried to get the proceedings brought on without success. That's paragraphs 31 to 33 of Clutterbuck. And the other point, just to mention, is at 44 of Clutterbuck, in Lord Justice Floyd, he made clear that as in Otcraty, there was no reasonable excuse for failure to comply with the Oldie guidelines. So those are the points. I think in a sense, it's a less, say it's less authoritative, it is perhaps unfair, but it's more fact-specific than Otcraty, but it's to the same effect. And I want
Can you give me the electronic page reference?
To that, yes.
Clutterbuck.
It is, let me find it. It's 3446, and it is Authorities Bundle 1, Tab 7. So, as I said, I just mentioned that for completeness. And in our submission, that approach is entirely contrary to the approach of the Guernsey Court of Appeal, who have done something which, in our submission, is effectively a breach of Article 6 in the way that they have shifted the burden of proof. And they have simply not engaged with the exercise of looking at the broad merits-based judgment and looking at the competing factors at all, contrary to the Deputy Bailiff. Now, the next point I want to raise, moving on if I may, is the Court of Appeal said that there is no evidence. And the next point we take issue with is that as well. In fact, before, on the strikeout application, both sides put before the court material from Guernsey 1. Initially, it had been put forward by Mr. Gonzalez on behalf of the former trustees, and much of the material in the seven bundles is his affidavit and the documents that from Guernsey 1 he exhibited. And therefore, the evidential question, really in a sense at the former trustees' behest, was dealt with somewhat more informally. And
I just give you the reference in our case. We have summarised the evidence and the position on that at paragraph 29 of our case. The reference to Mr. Gonzalez, it's his second affidavit, is electronic bundle, I'm not going to take you to it, electronic bundle 1123 at, in hard copy, bundle 3, page 1013. Now,
1123.
1123 in the electronic bundle, electronic page, and bundle 3, page 1013. That's Gonzalez 2. Now, what I do want to turn to in the evidence that he put forward is the material from Guernsey 1, which actually was relied upon by him or by the former trustees against Rawlinson and Hunter, but nevertheless is very much by way of evidence. And that explains what happened in the application to delivery up of the documents. And I can ask you to turn to electronic page 1171. And this is if you'd be kind enough to look at it's hard copy bundle 3, page 1059. This is in Mr. Hodges of Rawlinson and Hunter. Starts at 1055 in bundle 3, 1167 is the electronic page. And this was an affidavit which he made in support of the 2011 delivery up application before Lieutenant Bailiff Chadwick.
Where does it begin, the electronic page?
It begins in the electronic bundle at 1167, Rodney Hodges.
65 in mine. Never mind.
1165 is the cover sheet, my lord, yes. The first page is 1167. Can I take you to paragraph 18, please, on electronic page 1171, hard copy page 1059. And what he said in paragraph 18 was Rawlinson and Hunter replaced Investec as trustees 2nd July 2010. Investec have retained the assets of the trust, claiming their potential liability in the first application gives them the right of retention under the trust deed. They've also retained possession of TDT's documentation, but while for practical purposes they've allowed Rawlinson and Hunter periodic and supervised access to the documentation, they haven't admitted any complete right of access. And then paragraph 20, as I mentioned above, although Rawlinson and Hunter has now replaced them as a trustee, Investec retains the documents. Investec claimed their potential liabilities to the BVI companies, which are the subject of the first application, entitle them to retain reasonable security from the assets. Claiming their personal liabilities exceed the entire value of the assets, Investec have retained legal title to all of TDT's assets. As a consequence, Investec retained de facto control of the affairs and retained all the documentation. R&H doesn't accept Investec have any right to security over TDT's assets or to retain TDT's documents and reserved its rights. Pending resolution of these matters, practical arrangements were made for R&H to access TDT's hard copy documentation subject to strict controls imposed by Investec. In particular, R&H staff and lawyers attended Investec's office in Guernsey for a 2-week period in August 2010 to gain an overview of TDT's hard copy documentation and search for documentation on specific issues. Although 2 weeks may sound like a long period of time, given the extent of the hard copy documentation, 1,300 files, was only able to obtain an overview of the files during this period. And then in 22 to 25, they refer to the correspondence where they've tried to get hold of the documents and where Investec have effectively agreed that in principle and access, but that hasn't been able to work in practice. And they refer to in 24, he refers in 24 to the documentation they obtain and what's in it. He makes the point about the documentation has been intermingled with what Investec say is their personal advice, which they've received, and he points out that and makes a point about the intermingling at 25. So that's why they sought the documentation. And then if you go on, please, to 1273 in the bundle,
which is 1273 is Mr. Gonzalez. No, that's a wrong reference. Sorry, 11, I'm so sorry. Hard copy, yes, electronic 1273, that is right. Electronic 1273, hard copy 1161. And this is Mr. Hodges' reply affidavit, where he makes the point as to the purpose for which the Rawlinson and Hunter want the documents at paragraph 14 of EP 1273. R&H has always been clear the proper administration of the trust includes a duty to consider whether any steps should be taken to hold Investec to account in relation to their actions as trustee. This is obviously a matter of particular relevance given the current circumstances in which the trust finds itself. As Gonzalez states, Rawlinson and Hunter has pleaded a breach of trust claim against Investec in relation to the purported loan arrangements that are subject to the first application. Gonzalez suggests that weakens R&H's application, which he says is an attempt to obtain documents on an expedited basis of disclosure. And Mr. Hodges says that's misconceived, not a situation where they're seeking to obtain the documents which may fall to be disclosed. Documents which are being sought in this application belong to the trust, shouldn't have to wait to discovery to receive them, nor is their provision dependent on whether they fall within the scope of discovery. And then at 17, I note that Gonzalez comments a number of the search terms proposed do not relate to the arrangement. It's quite deliberate. R&H's duty to consider whether steps, including further claims, need to be taken to hold Investec to account for their conduct as trustees necessarily extends beyond the arrangements. The fact, for example, a particular contract for differences entered into by Investec may now be complete is irrelevant. The documents relating to the contract belong to the trust and I believe should be provided. The fact that in some cases they may give rise to claims against Investec is not a proper ground on which to withhold the documents from R&H. And we also make the same point, which is that the documents are, at least to a large extent, wanted to consider claims against the former trustees. In our skeleton, which I'm not going to take you to, but it's at EP 1405, bundle 3, page 1293. And finally, on this point, you can see in the judgment of the Lieutenant Bailiff Chadwick, which is now in bundle 7, electronic page number 2729 on this point.
2729.
2729, please. Bundle 7 starts at, sorry, did I give you a, sorry, the electronic, I'm so sorry. Electronic page is 2846. Apologies. Electronic page 2846. And it's 2729 in bundle 7, hard copy. And this is the judgment on the application for delivery up of Lieutenant Bailiff Chadwick at paragraph 9, where he gives reasons for ordering disclosure. The former paragraph 9, page electronic 2850, hard copy 2733. The former trustees submit it's an exercise which would be wasteful of time and money and would produce no useful benefits, and that anything that was identified as a result of a search of the entire electronic database would turn to have already been delivered in hard copy. Gonzalez doesn't actually say that in his affidavit. It's said on behalf of the new trustee. Gonzalez restricts his observations to the day-to-day administration of the trust. The new trustees are at least as interested in discovering how the trust came to be in its present circumstances as they are in the continuing day-to-day administration. Indeed, counsel on behalf of the new trustee accepts, frankly, that one reason for this application is to enable his client to investigate the possibility of claims against those who were formerly administering the affairs of the trust. In my view, it's impossible at this stage to take the view there won't be some material electronically not already available in hard copy form, which is of relevance to the carrying out of their obligations by the new trustees.
Where do you say this fits in? I mean, you say this, the other side of the coin is that it can't be right to suggest, as the Guernsey Court of Appeal did, that there may already have been enough material to bring such a claim.
Yes, I mean, the whole point about getting the documentation was to see whether there were claims, and that was expressed.
This is evidence of that,
This is evidence of that, and this was all before the courts. So, I mean, the Guernsey Court of Appeal, first of all, in my submission, just got the test wrong. But secondly, even on the basis that they did it themselves, they fail to recognise that there was this material before them about all the circumstances in which the documentation was obtained. And then over a period of time, there's documentation relating to extensions of time, but they arrive up to January 2012. And what happens then is about something like 70,000 documents appear in January 2012. Now, there is also, if one then goes back now to the Deputy Bailiff in his judgment, and we see that at paragraph 92 of his judgment at electronic page 78, please. And he then also refers to evidence before him in 2013, in paragraphs 92 and 93, in the context of whether these allegations, this is on page 78, and it's page 70 of hard copy bundle 1, paragraph 92 of the Lieutenant Bailiff's judgment. Further issue as to whether these allegations could have been raised in Guernsey 1 turns on what the plaintiff did after receiving the documents from the defendants as a result of its successful application to the Lieutenant Bailiff. And we've refers to what the Lieutenant Bailiff had said. And then we go on to a further application and this was after the Guernsey 1 trial, an application by the plaintiff for leave to adduce further evidence from Mr. Clifford and have him recalled. And this was Mr. Milner Moore's affidavit in support of that, because it shed some light on what happened in respect to the documents. The application failed, and what Mr. Milner Moore said, quoting from paragraph 92, the draft witness statement was in the possession of those advising the present trustee for some considerable time, and he explains effectively in this that a decision was taken, given what was going on at the time, was not to read the documents because there was essentially too much to do, and they weren't read until subsequently. And that is referred to in 92 and 93. So although these were actually this material was actually relied upon by the former trustees before the Deputy Bailiff, it explains that because of being engaged in preparing for Guernsey 1, in the event the decision was made not to read those documents at the time, and there was a point put before the Deputy Bailiff that the reason was lack of funding, which he rejected. So 92 and 93 are relevant. Can I just give you, without taking you to it, the reference to the evidence referred to here? It is actually in the Guernsey 1 bundles. It is MS 7181 at 7186. I'm not going to take you to it.
Say that again, MS?
MS, so it's a Guernsey 1 bundle, 7181 at 7186, paragraphs 18 to 19.
What's that going to tell us?
I'm so sorry.
What's that going to tell us?
That's just the reference.
Well, that's the reference to what's in the judgment.
For the affidavit, which is cited by the Deputy Bailiff. Just giving you that reference. So that is evidence before the Deputy Bailiff as to the fact the documents were not in fact read, the 70,000 documents, until after the Guernsey 1 trial. I want to move, if I may, and I see the time, to the question of overlap. The question of overlap between Guernsey 1 and Guernsey 3 was considered by the Deputy Bailiff at paragraphs 85 onwards. In fact, I think Your Lordships are on the judgment. If we just turn back a page, starts at paragraph 85 onwards, and then he goes through paragraph by paragraph of the Guernsey 3 pleading in relation to the question of overlap,
reaching the conclusion that there is, in 91, some areas of overlap, but not as much as suggested by the former trustees. Now, we would suggest that that process is without fault. Guernsey G3 has a different remit to Guernsey 1. Your Lordships have a long period to consider Guernsey 1 since this week. And as your Lordships know, it's focused on the August 2007 novation, the structure set up in December 2007 in the framework agreement, and the liability of the former trustees on the intercompany loans which remained in the books, and the questions about whether there was gross negligence or liabilities unreasonably incurred. Guernsey 3 was concerned not with those specific transactions which were dealt with by Lieutenant Bailiff Chadwick, but with the overall stewardship of the TDT by the trustees. And essentially, the allegation in Guernsey 3 is that, in effect, the trustees never stood back and considered, in the period of their stewardship, the level of risk in the portfolio and whether the investment opportunities proposed to them gave rise to excessive risk, given their independent obligation to protect the assets for the benefit of all the beneficiaries, including the miners, and to make sure there were enough assets there to pay day-to-day expenses, in particular in respect to the miners. That is the central distinction. Can I just briefly show you the pleading in Guernsey 3, which is page 128, hard copy, 1226 is the electronic page number.
1226.
No, 226 is the electronic page, and hard copy 1/128. I want to finish by as close to 3 o'clock as I can. It's paragraph 15 on electronic page 229 onwards. And
What is this?
this is the pleading in Guernsey 3. And you can forget about, so it's paragraphs 15 to 20, which are the key paragraphs. You can forget about 21, because it's already been struck out and there's no appeal. So 21 has gone. Can I just flag up? It seemed to me, on reviewing paragraph 16, that if you look at B and C, C is really just narrative, B is an allegation, but those two allegations do bear a similarity to Guernsey 1. If your Lordship is concerned about the similarity in respect of B and C, I am content for those allegations to go and to be struck out. I'm not going to fight for those, because that's not the purpose of G3. So if your Lordships consider that 16B and C are too close for comfort, as it were, to the allegations in Guernsey 1, they can go. Now, just for your reference, there are some further and better particulars. I'm not going to take you to them. At electronic page 306, hard copy page 208. And if I can give you one way of distinguishing, and perhaps your Lordships may or may not find this helpful, in relation to the work done as trustees, the former trustees charged a management fee for management of the trust as a trustee. In relation to the specific transactions which were in issue in Guernsey 1, they charge for the transactions on a time basis. It's a different department, in fact, as well. G3 is concerned with management, and the allegation in respect of that is that management was negligent in terms of the failing to stand back and consider how best to protect the trust. G1 is about the specific transactions. So when the Court of Appeal, so those are, that is the material. When the Court of Appeal then, at paragraph 87 of their judgment, which is at paragraph 87 is the paragraph where the Court of Appeal deal with overlap, and they criticise the Deputy Bailiff. There's this electronic page 25, paragraph 87 of the Court of Appeal.
and they criticise the Deputy Bailiff for his analysis, and they say that he failed to focus on the substance rather than the pleaded issues. Well, I mean, your Lordships will consider that. In my submission, there's just simply nothing in that. But then they say, they identify 7 matters which they say are similarities between G1 and G3. And without taking you through those in detail, given the time, we deal with those in our case at paragraph 41, where we point out that 4 of those 7 are just wrong. It's paragraph 41 of our case. So if I can just finally, as I said, I want to finish by 3 o'clock, what the Court of Appeal never did in my submission was to do the fact-specific analysis required from Johnson and Gore Wood. They just don't do it at all. They never engaged in the factors in the way that the Deputy Bailiff did, for and against. They never looked at prejudice at all, because although there was a criticism by them of the failure of what they said was the failure to provide evidence by Rawlinson and Hunter, in fact, what is striking is there was no evidence put forward by the former trustees of prejudice, which was one of the points made importantly in Ocrity. And if one then sees, first of all, the parties were different to this extent, that the BVI companies, of course, had no interest in G3, they weren't involved. There was a finding in that paragraph 104 of the Deputy Bailiff that the BVI companies would not have agreed, never challenged or engaged. There was a further finding at 104 of the Deputy Bailiff that bringing in G3 would double the length of G1. That wasn't challenged. He also said it would have transformed G1 into quite a different trial in the same paragraph. That wasn't challenged either. There was no suggestion or evidence from the former trustees that they would ever have agreed, if it had been put to them, to the idea that G3 would be part of G1. And the finding also that this wasn't a case where the Rawlinson and Hunter kept the claims up their sleeve at all. That wasn't challenged either. That's paragraph 97 of the Deputy Bailiff. In our submission, the judgment of the Deputy Bailiff sets out the right factors and a correct fact-based approach. By contrast, the Court of Appeal did nothing of the sort and simply adopted what we say is an entirely mistaken analysis as to burden of proof. Now, it's now just after 3 o'clock. And if there's anything further I can assist your Lordships with, those are my submissions.
Goes next, yes, Mr.
I think it's just me.
Yes, just you, isn't it? Yes, of course it is.
May it please your Lordship. The criticisms have been made, first of all, that the Guernsey Court of Appeal got the burden of proof wrong. Secondly, it said that they misunderstood the Aldi guidelines. Third, it was said that there was a lot of evidence from Rawlinson and Hunter about disclosure of documents, although I'll explain that that is irrelevant in this context. Fourth, it said that the Guernsey Court of Appeal was wrong when they identified overlap, and I'll deal with that and why the Guernsey Court of Appeal was right. And fifth, they said there was no evidence of prejudice from the former trustees. So may I deal with each of those submissions? My Lords, I think the starting point is to remind your Lordships of what the Guernsey Court of Appeal actually said and their understanding of the law, and in my respectful submission, they got the law absolutely right from beginning to end, and they were well aware that the burden of proof was on the former trustees to show first that the new claims could have been brought in Guernsey 1, but the Deputy Bailiff had already decided they could. In this context, could means that they were known, facts were known to the claimants, Rawlinson and Hunter, the Guernsey Court of Appeal was also well aware that it had to be shown additionally that Rawlinson and Hunter should have brought their new claims in Guernsey 1, and they repeated it on a number of occasions. And thirdly, they had to be satisfied that there was an abuse of process in the sense used in the Henderson doctrine as now interpreted in Johnson and Gore Wood. And if I may, I will go through the judgment. I have the judgment of the Court of Appeal in hard copy, and I want to go first of all to paragraphs 9 and 10, which are at page 3 in the hard copy. I think it's 11 in the electronic. And
10. Did you say you want to go to paragraph 3?
I want to go to paragraph 9 and 10 on page...
Oh, I'm sorry, yes, it's page...
Is it page 11?
Yeah.
Right. So the basic law had been agreed between the parties, had been summarised before the Deputy Bailiff, and both parties accepted it correct. And the Guernsey Court of Appeal set it out. And you will see paragraph 10, subparagraph 1, the burden of establishing that there is an abusive process rests on the party alleging it, Johnson and Gore Wood. So they were well aware of where the burden of proof lay. 2, the question in every case is whether applying a broad merits-based approach to the party's conduct in bringing the second action is in all the circumstances misusing or abusing the process of the court. 3, the merits involve not substantive merits or otherwise the second claim, but those relevant in the question whether the party in question could and should have brought his claim as part of the earlier proceedings. The question falls to be determined at the time when the plaintiff brings the later proceedings, in the light of everything that's happened. 5, it would be wrong to hold, simply because a matter could have been raised in earlier proceedings, that it should have been, thus rendering the raising of it in later proceedings necessarily abusive. 6, repetition of text from the pleaded case in the earlier proceedings does not necessarily demonstrate the claim. The second action should have been included in the earlier action. But key words this, but any overlap between the two claims must be assessed by reference to the substance of the respective claims. So the Court of Appeal were focusing, as we'll see later on what the substance was of the overlapping claims. 7 is not relevant here, nor is 8. 9, a party should not keep additional claims secret merely because they might involve additional, possibly complex issues, but should put its cards on the table so as to facilitate proper case management and know that no one is taken by surprise. So what the Aldi guidelines are about are not mentioning in a vague way that you might have some other claims which you've not yet identified. What the Aldi guidelines are about is going to the court, explaining that you do have claims and asking the court how they should be case managed. And then the question how one should approach the issue, has there been vexation, has there been an abusive process? In reaching its decision, the court must take into account the public interest in finality in litigation and in preventing a party being vexed twice, as well as economy and efficiency in litigation. But there had to be some acceptance that a party should have a measure of freedom, especially in complex commercial matters, to choose who to sue, in which action, who to sue. Now, Ocritti was all about the question of whether or not someone who had not been a party in a previous action should have been sued in that previous action. And then 11, again, is not really relevant here. It's more likely that a second action against a party to the earlier case will be struck out than a later action against a different party. The court will rarely find that second action is abuse of process unless it involves unjust harassment or oppression of the party alleging abuse. the decision as to whether the proceedings constitutes an abuse of process is not a discretionary one. Either the second set of proceedings is an abuse of process or it is not. Although even if found to be abuse of process, it may be possible in an exceptional case that the court might exercise discretion not to strike it out. Now, those were agreed propositions of law that were put before the Court of Appeal. Your lordships will see that nothing was said there about the need for the applicant, that's to say, the former trustees, to prove prejudice. And with great respect, the quotation from Lord Justice Chadwick is not something that features in any of the other judgments. The question is a slightly different one. The question is whether the applicant would suffer vexation, would be unjustly harassed. That is the question. And when we look at Johnson and Gore Wood in a moment, we'll see that unjust harassment includes being sued twice in relation to what are substantively the same matters. Because Johnson and Gore Wood is a doctrine not about issue estoppel, it's not necessary to show identity of issues. Instead, it's a more merits broad-based analysis of whether or not it's in relation to essentially the same subject matter. So having reminded itself of the law, the Court of Appeal looked at the parties' rival contentions, the history of the matter and the deputy bailiff's approach to it, and the discussion which led to their conclusion that there was an abuse of process begins at paragraph 82, which is electronic page 24. And they began by quoting from the well-known passage at page 31 of Johnson and Gore Wood in the speech of Lord Bingham, where he summarized the principles and he explained that Henderson abuse is not identical to action estoppel or issue estoppel, but it has much in common with them. The underlying public interest is the same, that there should be finality in litigation and that a party should not be vexed twice in the same matter. This public interest is reinforced by the current emphasis on efficiency and economy in the conduct of litigation in the interests of the parties and the public as a whole. The bringing of a claim or the raising of a defence may, without more amount to abuse, the court is satisfied. The onus being on the party alleging abuse, that the claim or defence should have been raised in the earlier proceedings if it was to be raised at all. And then there's a reference to whether it's necessary to show collateral attack or dishonesty. And where those elements are present, the later proceedings will be much more obviously abusive. And then he says, and there will rarely be a finding of abuse unless the later proceedings involves what the court regards as unjust harassment of a party. Just pausing there, if one, I'll show in a moment, page 32 to 33, a little further on, not in this passage, Lord Bingham said that being sued in relation to the same matter was unjust harassment if you sued twice in relation to the same matter. It's, however, wrong to hold that because a matter could have been raised in early proceedings, it should have been, so as to render the raising of it in later proceedings unnecessarily abusive. That's too dogmatic an approach to what should, in my opinion, be a broad, merit-based judgment which takes account of the public and private interests involved, and also takes account of all the facts of the case, focusing attention on the crucial question, whether in all the circumstances a party is misusing or abusing the process of the court by seeking to raise before it the issue which could have been raised before. So it is a broad merits-based test to see whether or not there has been abuse and unjust harassment. It's not enough to show the action could have been brought. It was necessary to show that it should have been brought, and a failure to do so was an abuse. There's then a review of the judgment of the deputy bailiff. And the striking thing, if I may say so, about the deputy bailiff's judgment was that he said, in substance, he said, I think there was not only a case that the Rawlinson Hunter could have brought their claims that they're now trying to bring in G3, in G1, but they should have. But, he said...
Let's look at that.
Sorry, do you want to see where he
Yes,
said that?
yeah.
It's quoted in a passage I'm about to come to in the Court of Appeal. But
Yes.
So, but they then, the deputy bailiff then got distracted, if one might put it that way, by consideration of what might have happened if there had been a hypothetical case management conference in Guernsey 1 about at which Rawlinson and Hunter had raised their new claims. And the deputy bailiff thought that he'd read all this evidence about the documents that were delivered up in between November and January 2011, and thought that there was a risk that if the matter had been brought before the deputy bailiff and Rawlinson and Hunter had tried to add their new claims, that would have caused a possible delay. Now, the essential reason why the Guernsey Court of Appeal said the deputy bailiff had got this wrong was there was no evidence to show that Rawlinson and Hunter had learnt about their new claims from the documents that were delivered up. And that was the basis on which they said the judge had misdirected himself. And we'll come to that in a moment. And if one looks at the judgment and reads between the lines, it is evident that Rawlinson and Hunter would have been, in all likelihood, as a matter of inference, well aware of these potential new claims long before they even became a party in Guernsey 1, and I'll explain the reason why. I'll give you chapter and verse in a moment, but the reason was this. From 2009, Mr. Hillier of Rawlinson and Hunter was protector of the TDT. And during 2009-2010, as appears from the Rawlinson Hunter's own written case, Rawlinson and Hunter were making complaints on behalf of Mr. Cengiz, the principal beneficiary of the TDT, about the former trustee's stewardship of the TDT. In June 2010, Mr. Hillier was replaced by Mr. Cengiz as the protector of the TDT. On 2nd of July, Mr. Cengiz, as protector of the TDT, appointed R&H to replace the former trustees as trustees of the TDT. Now, the matters of which complaint are made in the proceedings in G3 concern the investment management and the finance arrangements of the TDT. And you heard during the course of the G1 proceedings that the former trustees were acting at all times in accordance with the recommendations of R20, Mr. Cengiz's investment management company. And we've given references in our case, but the role of R20 was to advise the TDT on investments, financing and refinancing, and on document and monitoring all the activities. And so it is inconceivable, we respectfully submit, that Mr. Cengiz, and through him R&H, weren't fully aware of all the matters concerning investment management and management of the TDT, which are the subject of the allegations in G3. And if one looks at the judgment...
Is there
I'll give a chronology in a minute. I'll show you the
no,
chronology.
are there any references to this? Is this found by either court below, or is there any further evidence?
Could we look at the judgment, then the statement of facts and issues? Yeah. And could I remind you that this judgment was given by the President, James McNeill, who had only a short time before heard the retrial appeal between R&H and the former trustees, in particular, about the allegations in G1. So he had spent, I think, 4 days listening to what had been happening on the appeal in G1, and he was aware of all the matters that had been pleaded there, a lot about the evidence in G1 and of the role of R20 and James' role in all this. So he was in a uniquely good position to understand the overlap which I'm about to describe. So can I go on with the judgment to show you the basis on which the Court of Appeal reached their decision? First, paragraph 83, they dealt with the question of overlap, and they quoted from Lord Justice Lloyd's judgment in Stewart and Goldberg-Linda, and you'll see that at the final sentence of the quotation...
Sorry, which paragraph is this?
I'm sorry, paragraph 83 of the Guernsey Court of Appeal's judgment. Page 24 of the electronic, page 16 of the hard.
Good, right.
Now, the overlap between the two actions needs to be assessed, it says in the final sentence, by reference to the substance of the respective claims, not by a literal comparison of the two statements of case. And that was one of the criticisms that the Guernsey Court of Appeal made of the Deputy Bailiff's judgment. They pointed out that an appellate court should be reluctant to interfere with the determination of the court for first instance in respect of the balancing of relevant factors, see Aldi. But issues such as a failure of logic may dictate the need for a review. Apart from that restricted ambit of interference, the court will only interfere in cases exhibiting what are commonly referred to as Wednesbury unreasonableness, namely their court having taken out irrelevant factors, having failed to take out irrelevant factors, having been error on principle, having reached a first decision.
So what were the relevant factors here which... was it failure of logic? Was it Wednesbury unreasonableness?
No, it was taking into account the hypothetical case management conference that the deputy bailiff, that tilted the balance in the deputy bailiff.
Why isn't that a relevant factor?
Because in this case, the hypothesis on which he proceeded was fundamentally flawed.
What was that?
And the fundamental flaw was that R&H failed ever to state when they first knew about the claims in Guernsey 3. They were pressed in the Court of Appeal hearing and asked, well, when did you first know? And they never gave a clear answer. And we'll come to that over the page.
So you're not challenging Lady Justice Arden's analysis that in principle the outcome of a hypothetical Aldi Stalls application may be relevant. You're just saying that the deputy bailiff simply he constructed an inappropriate hypothetical.
Exactly, my lord. Exactly. So, 85, then, we see, in approaching his task, the learned deputy bailiff considered first whether the relevant part of the cause could have been raised in Guernsey 1. He found it could have been, and that hasn't been challenged. But what could means, of course, is that you know. If you don't know about your claims, you can't say that you, it can't be proved that you could have.
But supposing the view had been taken at, so it's a question of timing, really. You're saying that the Court of Appeal's hypothetical case management conference is irrelevant because it's postulated upon this issue coming to the notice of R&H rather late in the day, and the case management conference being therefore fairly short before trial. And we heard some factual submissions from Mr. Hollander on the actual date. But assuming you're right that there isn't any evidence that it only came to notice of R&H at a late date, you'd still have a hypothetical case management conference at an earlier date, and you might take the view, looking at the substance of the issues in this case, that there are different sorts of case, that it would double the length whenever the hypothetical case management conference takes place, that the BVI companies wouldn't want it in, they wouldn't be interested in this sort of issue, and that it would be a nightmare to try the two together, which appears to be broadly the view of the Deputy Bailiff.
Well, the chronology is this, that the breach of trust claims in Guernsey 1 were brought in August 2011. And so there's nothing to indicate that R&H weren't fully aware of all those matters in 2011.
Yes, well, I'm taking the point. I mean, it still doesn't answer the question whether it would have been at all convenient or whether it was requisite to avoid abuse that you include this completely different nature of claim, as it's said, I know you dispute that, in the original counterclaim. I mean, the reality is that on the way it's put against you, this is a completely different category of claim. Looking at the whole investment strategy, it's now accepted that you can't re-engage, or wouldn't, claimants, R&H couldn't re-engage with the strategy when constructing the Oscatello structure, but in all other respects, this is said to be a different kettle of fish, and any case management conference or any claim could properly be structured so as to exclude it and to try it separately.
But we then come on to the conclusion of the Guernsey Court of Appeal that it was essentially the same transactions which were an issue, and I'll show you from the statement of facts an issue why we say that in a moment.
Yes, well, that may be an important point.
My Lord, yes.
Your criticism of the Deputy Bailiff isn't confined to what you say is the incorrect hypothesis relating to the case management conference. You also say that his assessment of the overlap was focused on pleadings when it should have been focused on substance.
My Lord, yes, and
as
that's
I understand.
exactly.
And you're coming on to that later.
That I was coming on to, and so I'm trying to follow the course of the judgment rather than jump around. Forgive me, my Lord, if it's not always obvious where I'm going. Can I go back then to paragraph 86 of the Guernsey Court of Appeal judgment? It's page 25, electronic, page 17. At paragraphs 83 to 95, the learned Deputy Bailiff expressed no firm view as to the degree and extent of overlap between the claims made in paragraphs 15 to 20. It's clear that he considered the extent and degree to be sufficiently palpable to make justiciable what to him was the logically separate query, namely whether the claims should have been raised in Guernsey 1. So he thought that there was enough overlap to at least raise the question whether they should have been. Were there to be any lingering doubts as to that characterization of his position, it's dispelled by his emphasis in both of paragraphs 106 and 111 as to the fine balance of the matters before him. In his mind, therefore, the defendants have presented a very real issue as to whether or not the present claimants' claims should have been pursued within Guernsey 1. In our judgment, the circumstances before the learned Deputy Bailiff were such that upon this initial analysis, his determination ought to have been not only that the allegations could have been brought in Guernsey 1, but also that this should have been done. So it's what the Court of Appeal is saying is that if one looked at the substance of the claims in Guernsey 1 and in Guernsey 3, the overlap was such that they should have been brought in Guernsey 1. The Deputy Bailiff focused in some detail on the question whether the pleaded issues in Guernsey 1 overlapped with the pleaded issues. But it seems to us, with respect, that what the learned Deputy Bailiff failed to do was to analyse and emphasise the substance of the respective claims. Upon such an analysis, it can be seen that, although there is not a precise identity between the two, the claims in both actions involve essentially the same parties, acting in essentially the same capacities, in relation to events occurring in essentially the same time period, and in relation to essentially the same series of transactions, raising essentially the same cause of action, breach of trust, whose disposal would turn on essentially the same documentary evidence and essentially the same witnesses. That is the accumulation of reasons why, having decided that the allegations in the cause could have been brought in Guernsey 1, the court below ought then to have come to the conclusion that, absent any special reason, those allegations should have been brought in Guernsey 1. So, with respect, the first criticism the Guernsey Court of Appeal got the burden of proof wrong. In our respect, it is wrong. The Guernsey Court of Appeal got it absolutely right. They asked themselves whether the case should have been brought, and they identified those factors there. And if one pauses for a moment and thinks about the rationale of the Johnson and Gorwood principle, the reasons why it's an abusive process to litigate in relation to essentially the same series of transactions is because of the duplication of legal costs, the duplication of management time for the former trustees and its employees, the duplication of searching and reviewing documents, the vexation and stress that flows from this, the vexation and the time that the witnesses have to put in, being cross-examined twice, the waste of court time and resources. And those factors, when allied to what was established there, are enough to establish an abuse of process. And what the Court of Appeal was saying is that once you've got that degree of overlap, you really should be bringing your subsequent claims in the first action. And in our respectful submission, that is the approach that Johnson and Gorwood recommends. It's looking at it in a broad merits-based way to see whether the defendant in the second action is being vexed twice. What the Court of Appeal then went on to say that once you've got to that position, once you've shown what appears to be a strong case for abuse, the onus must at some point shift to the claimant to explain why and give a good reason why they didn't bring their claims in the first action.
That's right. It's odd that they didn't put it quite that way in paragraph 93. One would expect to see the second sentence saying, the learned deputy bailiff having identified the present plaintiff should have raised the relevant part. Then it was that the burden shifted to show why that wasn't done. He didn't say that, he said could.
My Lord, I accept that's obviously the basis on which but one has to look at the reasoning in between to understand why, having decided there was a case already at 87, why they thought the deputy bailiff had gone wrong. And the reason why, as I say, is if one goes to look at the passages between 88 and 92. Returning, 88, page 25 electronic, page 17 hard copy, returning to the approach of the learned deputy bailiff, without reaching a firm view as to the degree and extent of overlap of the two proceedings, he moved to deal with the second stage of analysis through consideration of the likely approach of the lieutenant bailiff at first instance upon the hypothetical event that an application was made in advance of the trial in Guernsey for inclusion of additional claims as presently presented in paragraphs 15 to 20. His logic appears to have been that the basis and compulsator for making the new allegations was the then recovered documentation, and that, given the stage which Guernsey 1 had reached, an application for amendment would be required. In other words, the circumstances here did not disclose a simple situation where a litigant could take responsibility himself or herself for failing to introduce matters into the earlier litigation.
Sorry, where are you reading it then?
So paragraph 88,
Yes.
bottom of the page, 88. Page.
Yeah.
So,
It's the fact that the information, the hypothesis was the information came at a stage where the present trustees would have to amend,
exactly.
rather than coming in at the outset with the claim.
Yes. Yeah.
Yes.
And whether or not we are correct in the views expressed in paragraph 88, in our judgment, the learned deputy bailiff at this stage erred in that he took into account a matter which, in the whole circumstances before him, was irrelevant. That is, what might or might not have happened at a case management conference. The general principles which they remind us of, which are set out at paragraph 10 above, expand upon the general principle that a person is not to be vexed twice with litigation unless there's good reason. In the circumstances before the learned deputy bailiff and before this court, the present defendants are about to be vexed twice in the instance of the present plaintiff, which presented its counterclaim against them in Guernsey 1, and the learned deputy bailiff, with whom the plaintiff does not disagree, found that the allegations could have been brought in Guernsey 1, so the R&H accepted they could have. What is lacking before this court, as it was before the learned deputy bailiff, is any sufficient evidence or reasoned basis to explain when the claims in this cause were first identified and why the new allegations were not brought in Guernsey 1. Guernsey 1 started with an application by the present trustees for declarations regarding their position as regards the BVI companies. The latter made their specific claims for payment, when shortly after the defendants were replaced as trustees by the plaintiff, R&H, was added as a party and presented its own claim. That counterclaim dealt with allegations of breach of trust relevant to the claims by the BVI companies. At that stage, and this is the crucial, at that stage, the plaintiff had been given access to hard copy trust documentation, and had access to, amongst other potential witnesses, Robert Cengiz. And he was the man who was directing what investments should be made, or making the recommendations throughout as to what investments should be made, and what the banking arrangement should be. So the Guernsey Court of Appeal had it well in mind that that this was a relevant factor. Remember, my lords, the pleaded case was that it was wrong to rely on R20 in relation to all these matters. R20 was Mr. Cengiz. He was the director and the chairman. Now,
That's probably why Mr. Hollander referred to the trustees' obligations to minors.
that may well be. After having accepted appointment as trustee, that's R&H, but before being made a party to Guernsey 1, the present plaintiff had commenced its own proceedings against the present defendants for delivery up of trust documentation for the specified purpose not only of obtaining trust documentation necessary for the administration of the TDT, but also for appraising whether and to what extent there might have been culpable conduct on the part of the present defendant in respect to the losses in asset value with which the TDT is sustained. And they then point out the delivery up occurred in 2010, a significant number of files was received, and the plaintiff has sought to this is 92, the plaintiff has sought to suggest that concentration on Guernsey 1 was in some sense to blame for a failure to concentrate on what had been recovered. And this is the critical finding. However, there is no evidence that the proposed new allegations depend upon information only discovered from an examination by the plaintiff of the documents recovered in late 2011 or early 2012. Nor is there any suggestion that the proposed new allegations depend upon witness evidence from individuals who are not known or available to the present plaintiff prior to having access to those documents. To the contrary, we were informed by counsel for the plaintiff that amongst the relevant witnesses supporting the new allegations would be those who gave evidence on behalf of the plaintiff in Guernsey 1. The persons who gave evidence on behalf of R&H in Guernsey 1 were Mr. Cengiz, Mr. Smalley, and Mr. Brown. And they were the people who were the directors and employees of R20. So it's in that context, my Lord Briggs, going back to your question, why did it was put that way? It may be that it's not well expressed, but if one looks at the sense of how the Guernsey Court of Appeal approached the matter, we respectfully suggest that on a fair reading of this judgment as a whole, they were well aware of the requirement, of the need to show, of the need to establish that R&H could and should have brought their present claims in Guernsey 1, and that it was abuse not to do so. And the reason why they talk about the shifting of the burden was because, given the overlap, given it was essentially the same matters, as we say, and as the Guernsey Court of Appeal themselves thought, on the basis of a much greater knowledge of the matter than anyone else, it was therefore incumbent on the R&H to give some explanation of why they hadn't raised this before.
You said earlier, I think, to my Lord Briggs, that you didn't criticise consideration of the case management conference, but I think on the analysis you've just given us, he should never have considered a case management conference. He should have considered what the position was at the moment of the counterclaim.
That's given that there was no explanation tendered
Yes.
by R&H as to when they knew about these claims.
Yes.
And given that they had, Mr. Cengiz had appointed them, and said at one...
I think your answer to me was only that you didn't criticise Lady Justice Arden's analysis,
I see.
that an Aldi Stores, a hypothetical Aldi Stores analysis can be relevant. But I think I understand you to say this wasn't really an Aldi Stores case at all.
Exactly.
Because the true emphasis you say should be given in 93 is having identified that the plaintiff could have raised the relevant part of the present case as part of Guernsey 1. In other words, rather than by a later amendment.
Yes.
Well, I'd just like to see that was actually the way it's put in front of the deputy bailiff, because if it is, then his judgment has clearly mistaken the issues. Paragraph 92 of his judgment says clearly that the issue we're currently discussing turns on what the defendant did after receiving documents from the defendants, what the plaintiff did after receiving documents from the defendants as a result of the successful application dated 8th of August. And there's no trace of him recording this current issue as far as I can see. So I think if there are some written submissions before the deputy bailiff where this point is raised, in the way that it's put before the Court of Appeal, it would be helpful to see them.
Written submissions from whom, my Lord?
Well, don't the parties put in some sort of case or skeleton in the before the deputy
I see.
bailiff?
Sorry, yes, I'm sure they do. Yes,
No, I think it'd just be helpful to see it, just to check.
I'm afraid
because,
I couldn't put my finger on that.
I mean, cases do sort of wander off track sometimes, and the points become very important. But at the moment, I'm puzzled as to why the deputy bailiff, I mean, maybe this is why he's wrong, but we've been shown material from Lieutenant Bailiff Chadwick and also an affidavit of Mr. Milner Moore, which proceed on the basis that these, effectively, that the documents were necessary in order to decide whether there were further claims. That was disclosed, and that was in the application of August 2011, which was made at the same time as the counterclaim. So, I mean, to hear you say, well, at that stage they ought to have been suing in the counterclaim rather than applying for the documents, slightly surprises me.
Well, the purpose of the application for the documents was presented on two footings, if you recall. R&H, not Mr. Robert Cengiz, R&H was saying, we need these documents in order to administer the TDT. That was
yes, but Lieutenant Bailiff
then
Chadwick...
they went on. Sorry.
Yes, they went on, as you said.
And in the course of the application, which, as I understand, in separate proceedings for these documents, they said they might also have to be investigating claims. But if they the point that the Guernsey Court of Appeal was making was none of that material, none of the material put in by R&H subsequently in G3 said we only discovered these claims as a result of a search of the documents. And we've referred in our written case to the way in which the Guernsey Court of Appeal did press the advocate for R&H at considerable length, apparently. Say, well, when did you know about these claims? And
well, we've got the references somewhere.
We've got your skeleton argument, or rather, we've got the skeleton arguments before the deputy bailiff, but unfortunately, they haven't got electronic page numbers attached in the index. They may have got electronic page numbers, but if you go to the index in the bundle, you can't find them.
I think in the time available, I'm going to find it difficult to track them down, and I've got a couple, one or two other things, please.
Well, I mean, it is puzzling. Anyway, that's the point which, at the moment, I'd like explored in some way.
I'll ask my juniors to look at it while I'm trying to address you on the matters I've got to cover, please. Now, the other point was about the overlap, and the Guernsey Court of Appeal was not satisfied that the deputy bailiff had appreciated the extent to which these claims essentially arose out of the same transactions. And the reason why, trying to put it in summary, the Guernsey Court of Appeal thought these arose out of the same transactions is this. I explained to your lordships this morning that the borrowings from Kaupthing and the borrowings within the structure were required to finance margin accounts. And the margin accounts were what were required to hold the core investments through CFDs. The core investments, you recall, were CFDs in public equity holdings like Sainsbury's, Mitchells and Butler and Summerfield. So decisions about what to do with borrowing were intimately connected with decisions about what to do with investments. They were really opposite sides of the same coin. One gets that. I'm going to try and summarize it in the time available, but it's in the statement of facts and issues, the way things worked in between paragraphs 13 and 19. But can I try and explain to you all?
How long are you leaving for a reply? Any time?
My lord, can I just finish this point about the overlap?
No, I'm not. I've just inquired. Have you agreed something?
Yes. My learned friend and I agreed that I should have. I think we agreed that he should have an hour and I should have 45 minutes. We've got slightly longer than that as a result of the 15 minutes that we. So if I may just take 5 more minutes, is that okay? The overlap point, my lord.
We have to rise at 4.
Yes, upwards. The overlap point. As I explained, a decision to sell the investments, the core investments that are described, and the pleading in G3 refers to the core investments, was obviously closely linked to the question of what would happen if you tried to sell them and flood the market with these very big holdings. And the question, therefore, arose, should the TDT companies borrow, including through the framework agreement, so as to enable them to retain the core investments, or should they liquidate them at the risk of huge loss as a result of a forced sale? So the questions about management of the assets were really about the same subjects. And this is the point that the Guernsey Court of Appeal appreciated, because the President had sat through the Guernsey 1 retrial appeal and knew what it was about, the facts had been about in Guernsey 1, and he also was listening to these new claims. And he could see that there was this overlap. The Guernsey 1 trial had been focused on the recommendations from R20, what should be done about the investments and the borrowing, being long cross-examination of R&H's witnesses, Mr. Cengiz, Mr. Smalley, and Mr. Brown. And one of the most sort of vivid pieces of evidence in Guernsey 1 was the point that Mr. Brown had, on behalf of R20, had said to the TDT trustees, administrators, we've really got to get this framework agreement signed, because otherwise Kaupthing could liquidate the entirety of our investments. And that was a matter which we refer to it in the retrial appeal document. It was a sort of critical moment in the eyes of the deputy bailiff, and it showed the inextricable link between the decision to retain the investments and the decision to go ahead with this new type of borrowing structure. So these matters were going to be canvassed in Guernsey 3 all over again. And it was for that reason.
I think isn't that the point that Mr. Hollander has sought to separate out, that there now is going to be no complaint, he says, or he offers to abandon any complaint that about the Oscatello restructuring, the framework agreement.
But it's an unrealistic concession to make in circumstances where the decision to retain the investments is inextricably linked to the question of what you do about borrowing and the margin accounts. That is why the Guernsey Court of Appeal concluded that these claims were really asking the court once again to investigate the same transactions, the same decision.
Well, leading up to December, up to the framework agreement, you mean? Effectively, you're saying that this nature of complaint about your strategy, it all ends up with the framework agreement, effectively, and you can't conceive of some complaint about the way the structure operated without challenging the framework agreement. And effectively, he said that he won't do that, so this can't go ahead.
That's why he said it. There's crucial findings in paragraph 87 of the Court of Appeal's judgment, were just a reflection of what the action was really seeking to do. It was seeking to trample over exactly the same events, same series of transactions, in relation to essentially the same series of transactions. That was the conclusion they reached. And in our submission, that it was, once you understood the link between the core investments and the decisions about borrowing, that was an inescapable conclusion, and it was correct in our submission. Well, I've had more than my time. Unless I want to ask further questions, I probably ought to stop. But.
Thank you very much indeed. Yes.
I'll respond in 5 minutes. Your Lordships have my submission that the approach in substance of the Court of Appeal was that once there was a breach of the oldie guidelines, then effectively the matter was an abuse, unless the court was satisfied as to why the matter wasn't brought before the court during the previous proceedings. Your Lordship's got that point. The reference that my Lord Mance asked for in terms of the skeleton argument below, it is electronic bundle 667, and the relevant page is 673.
Hard 667.
The electronic page 667 at 673, hard copy 563 at 569. and that's volume 2 in the hard copy. And your lordships will see that in these cases...
Where's it? Which paragraph in that skeleton?
It's the section, I think the relevant section to read is, starts at paragraph 28. I think your lordships would need to read that section, starting at paragraph 28 of the skeleton.
Oh, I see. Okay. You may need to. What do you say we get from that?
Well, it's slightly complicated, which I didn't want to go into, but essentially they were saying this was a deliberate attempt to vex twice a complaint which was rejected by the deputy bailiff in terms.
This is the former trustees.
It's slightly more complicated than that, and I don't want to be unfair to it.
We'll look at it.
I'm sure your lordships will look at it. Yeah. Many of these cases, there is no explanation given as to why. This is the explanation is not perfect in terms of one understands a criticism as to why one could have said more, but many of these cases, there is no accepted explanation. Ocraty and Clutterbuck are cases where, in the relevant respects, the court said there is no acceptable explanation, but nevertheless not an abuse. The court is concerned with the abuse issue. So far as I've indicated a willingness to abandon the complaint regarding the framework agreement. This isn't a summary judgment application. To the extent that my learned friend complains about overlap in my submission, that is a complete answer to that.
Well, wait a minute. What are you going to claim on what sort of basis, assuming you have to accept the Oscatello restructuring?
Yes.
How do you frame your complaint about the investment management? Isn't it really going to end up as a complaint that you shouldn't have been in a position where there was any Oscatello restructuring? No?
This is a much wider complaint about the strategy. Essentially, what happened was they didn't stand back, is essentially the complaint. You have an investment advisor who is advising you, putting forward investments and saying, look, this looks like a jolly good investment. But you haven't got someone standing back, as the trustees should have been, and saying, well, hang on a second, it may be that this looks a jolly good investment, but we have to take into account the risk profile, the obligations we have to the various beneficiaries, and look at it much more broadly, and they never stood back. And that's essentially what the G3...
So you say that you'd still have been in the same position as regards the company loans which gave rise to...
We're not complaining about that in G3. We're complaining, and we make that very clear, because I think that is, with respect, important, and I understand why the learned friend focuses on that point. So far as the learned friend says, well, there is prejudice because there's a harassment in being vexed twice. If that were right, every case of this sort would be an abuse. What the Court of Appeal in Ocraty were talking about when they were looking for evidence of prejudice was by definition something which went beyond that, beyond the prejudice that occurs in every single case where there is a second action, because that is the starting point. And that is what is lacking. And it is interesting that when I said to your lordship that there were no challenges to the findings of fact, to the conclusions at 104, that important paragraph in the judgment of the deputy bailiff, where he looks at the problems with having a Guernsey 3 put into Guernsey 1. And learned friend's only answer to that is, and I think this is a point my Lord Mance made to him, is a temporal one. Well, you can debate whether the evidence about the circumstances in which it wasn't brought, whether there's evidence sufficient about what was known at what time. But there's no answer to the non-temporal factors at all, namely the doubling of the length, the making it a completely different exercise, the fact that the BVI companies would not have agreed, and indeed it has never been suggested by the former trustees that they would have agreed, and that's a fundamentally important factor, as to whether they would, if the offer had come to bring this into Guernsey 1, whatever date, as to whether they would have been prepared to put up with that all going into Guernsey 1. And none of that is challenged, in effect, and that's the key 104. There were times when my learned friend appeared close to challenging what my Lady Justice Arden said about being appropriate to consider a hypothetical CMC.
Well, he didn't ultimately.
But if there is a basis, and you're challenging whether there is a basis for saying that the Deputy Bailiff erred in not considering the scenario of these claims coming in at the outset, but if there is a basis for that, would it be a matter of R&H consenting, or would it simply be a matter of a counterclaim being pursued with no discretion on the part of the court?
Well, the court would have, hypothetically, the court would have to consider. Let us assume that what was done was R&H comes to the court at a case management conference. Let's not worry about the precise time for the moment, and says, look, we want to bring these claims, even assuming that they had the material to do that, which is another issue. And what would have happened? The court would have obviously had to take a view in the public interest, the court's decision, but it would no doubt have taken into account the views of the BVI companies, whether they consented or whether it would have been appropriate to force that on them. And also it would have been appropriate to take into account the views of the former trustees as to whether they would have consented. My point is that instead of coming and saying, well, of course we'd have wanted to have it in Guernsey 1, they have never said that. They've never put in evidence to suggest that. They simply, they have never actually put forward a position at all as to what would have happened, which is why one comes close.
Does the commercial court sever cases as order separate issues as frequently as it used to?
Well,
I mean, one envisages if this had been brought in originally. I mean, what's happened on the analysis Mr. Taub's proposing is that there was a sort of unilateral decision to sever by not including. But if it had been included, one wonders what attitude the commercial court would have taken. If they're really separate issues, it might well have said, let's try them separately.
well, I mean, what your lordships have, paragraph 104 of the Deputy Bailiff, where he expresses the view as to what would have happened. I appreciate that in part he is assuming that that the documents should have been read on arrival, and that would have, say, taken till April 2012, which is shortly before the trial. But even if that were wrong for any reason, one still has the position of a fundamentally different trial. And most of these cases, there isn't an explanation which satisfies the court. I'm going past the time. So, my Lord, I think, and then also said, because one member of the court had prior knowledge from previous hearing, that put them in some special position. I have to say, I thought that's a rather dangerous submission. If one of your lordships had a prior knowledge of this case from a previous hearing, I don't think that would give the court a particular advantage over what would be otherwise. But anyway, that's a. But I think. I mean,
I've forgotten what the suggested prior knowledge was. So
having heard a previous application,
have it if it was me.
Having heard a previous application, it's gone past 4 o'clock. I mean, is there any particular points that you want me to deal with?
Yes, we have ended up in a slight rush. I mean, if there is anything more that either side, with afterthought, thinks should be put in writing, but I don't think we want to invite that.
Break my duck by offering a reference. You did ask where you might find where the temporal point was taken. In our reply skeleton, there was an initial skeleton argument, then there was a response to R&H, and the reply skeleton, which you find starting at the MS 743.
And in hard copy?
743, yes, hold on.
And the passage I would direct your lordships to is at MS 756, hard copy 652, paragraph 48. And it's really the bottom half of that paragraph, and then we make some points after that.
So for the geeky electronic people, it's 743 at 756.
Yes.
Yeah.
Yeah, thank you.
So that's your reply,
Yes.
is it? Yeah. Very much. Right. Well, on that basis, Mr. Honda, is that all?
I think that's all.
We're very grateful to Council for getting through all the material and in a way which has been very clear. I think it will take, the board will take time to consider what advice it will tender to Her Majesty, and maybe Her Majesty will take time to digest the advice.
Je m'en vais.